and Representative Wojcicki. Thank you, Christy. Sorry about that. So we are now recording this public hearing. The public hearing was established to receive comments from those individuals in the Department of Corrections related to publications that the Commission has posted. The first are proposed parole guidelines, and the second proposed recommitment ranges. And I believe copies of those documents were provided to all the individuals who are testifying this morning. We're really pleased and thankful to the Department of Corrections for making all the arrangements so that we could engage with 4 of the state correctional institutions. We'll be hearing from individuals from SCI Cole Township, SCI Benner Township, SCI Fayette, and SCI Muncie. And so I thank you all for participating and for your thoughtful comments that you provided in writing. Any comments that were provided to the Commission in writing have been provided to all members. And we'll continue to collect any kind of information. We have another public hearing tomorrow, and we will be hearing from individuals then, and we have received public testimony for those individuals as well. So just wanted to thank you all for engaging this process. As was noted in the publication, 2 years ago, the Commission approved and submitted for public hearings preliminary parole guidelines and preliminary recommitment ranges. And following public hearings, the Commission made some modest changes to the parole guidelines, recognized there was a lot more work that needed to be done for the recommitment ranges, but knew that had to be done in conjunction with other changes, both changes that the Commission had underway with sentencing guidelines, but also the rebuilding of a risk assessment instrument at the Department of Corrections. We have worked with the department and with the board over the last 2 years in trying to bring about a new risk assessment instrument, moving from the LSIR to the strong R for use at the Department of Corrections. And unfortunately, although a lot of progress has been made, that instrument is not available yet. It hasn't been put in place or validated. But the LSIR that is being used has been validated. Although the Commission expressed some concerns about it, it's important to recognize that the LSIR is being used right now. So the parole board is using the LSIR to inform their parole decisions using their internal decisional instrument. And so the Commission has decided to move forward with these guidelines. These are advisory guidelines. And if nothing else, as a means of trying to make sure there's greater transparency in what's happening and to test the decisions that are being made with the internal decisional instrument or with these proposed guidelines. So with that, I'm going to turn to the 4 institutions and to the individuals there that are scheduled to testify. And if there's no objections, what I'll do is just go through the names as they're listed and ask that individual to testify, ask everyone else to mute their audio so that we don't have any feedback. And then members are welcome to ask any questions to those individuals who testify. Once we complete the discussions with one institution, we'll move to the next and eventually go through all 4 of the institutions. So with that, I'd like SCI Cole Township to make sure their audio is open. Everyone else is muted. And then at SCI Cole Township, there's 3 individuals that I have listed as testifying: David Lee, Keith Morrison, and Kenneth Carr. So how about if we start with Mr. Lee?
Thank you, sir. First on my agenda is to thank the Pennsylvania Commission on Sentencing and the Cole Township Administration for allowing me to speak at these public hearings. I really think that it's important for incarcerated people to be allowed to voice their thoughts on these public hearings because it allows for a more diverse range of opinions. My name is David Lee, and from my understanding, a major part of the Commission on Sentencing is maintaining public safety, and that should be a major concern. With that being said, it is vital that we understand how important it is to invest more resources into trauma healing within the incarcerated population. the vast majority of incarcerated people will eventually return to the community. And it is essential for them to return as healthy in a healthy state. Now I'm gonna turn my attention to RRI, Recidivism Risk Reduction Incentive, Title 61, PA, CSA, Section 4503. Eligible person, a defendant or inmate convicted of a criminal offense who will be committed to the custody of the department and who meets all the following eligibility requirements, does not demonstrate a history of present or past violent behavior. This is part of Title 61 PA, Section 4503. Recommendations. As currently constructed, RRI does not provide relief for people who have been incarcerated for violent offenses, and it would benefit incarcerated people, prison administrators, and our communities to provide incentives for people who are incarcerated for violent crimes. Therefore, providing good time for violent harm doers is something that all parties could benefit from. All human beings possess the capacity to change, and this includes people who are incarcerated for violent crimes. Thus, it would benefit all of Pennsylvania to understand this fact and adjust laws to accommodate our current reality. Again, most people incarcerated PA will ultimately return home, and it is important to address their needs as human beings. And this includes people incarcerated for violent crimes. RRI should include more incentives to address the needs of violent offenders. And I think this commission should consider how many incarcerated people have been exposed to ACEs or adverse childhood experiences, other forms of trauma, and relate those adverse childhood experiences to reasons for many criminal behaviors. The need for public safety is connected to understanding trauma and the need for healing on all sides. People who have been harmed by crime and harm doers should be placed in a position to best heal from their traumas. It is important to understand that the vast majority of incarcerated people are people of color. Based on studies, African Americans make up less than 11% of Pennsylvania's population, but 65% of people serving life sentences and 58% of those serving non-life sentences of 20 years or longer. Pennsylvania's extreme sentencing practices are responsible for an aging prison population that is not slowing down. Therefore, the need for legislation to address this growing problem is necessary. Now, I do understand that this commission is not a legislative body. However, this commission does possess significant influence. Second chance legislation could drastically reduce the aging prison population by allowing older incarcerated people to return to their communities as tax-paying citizens, especially after spending decades in prison and demonstrating significant changes in conduct. Asking PA legislators to support bills like HB 1719, which could return the vote for commutation to a majority, 3 out of 5 for people serving life sentences, will go a long way towards reducing the aging prison population. Also support SB 835, the geriatric bill will significantly reduce the aging prison population because it will provide relief for incarcerated people serving life sentences and virtual life sentences. There have been many studies conducted to show that aging people are at a drastically reduced risk for recidivism. Furthermore, we can see all the wonderful work being done by many of the juvenile lifers who have been released and can witness the benefits of releasing incarcerated people who has transformed into people who care about and love their communities. In closing, I want to say that I understand that we, incarcerated human beings, are in prison for harms that we have committed in our communities. And many of us are deeply sorry about our actions. Moreover, many of us have demonstrated that we have changed for the better and care deeply about the communities that we come from. Thank you for your time and for your consideration.
Thank you, Mr. Lee. Any questions or comments from Judge Tucker or Representative Krajewski?
Yes, good morning. This is Judge Tucker. I do have a question. Mr. Lee, how long have you been incarcerated?
For 34 years, sir.
And obviously, based on the tenor of your conversation, you understand and appreciate the benefits of what the commission could do. Could you be a little bit more specific in terms of your suggestion of what the commission?
Well, basically, yes, Your Honor. Basically, the first thing in my thought process is that we have a lot of people that's incarcerated with violent offenses who could benefit from legislation, a change of legislation, especially when you start talking about triple I. Right as of right now, there is no incentive for somebody who incarcerated for a violent crime to change. And if we talk about a society or an institution that's designed to help people make changes or transformations in their lives, wouldn't it benefit us to create some sort of incentive-based, process for violent offenders?
I guess that's what I'm asking you. What do you see that would be beneficial as an incentive?
Well, a time reduction. When you start talking about a good time bill, for instance, let's say, for every 2 good days somebody served, they get a day off. They get a good day. So this way, this is an incentive for somebody to do the right thing. If we want people to stay out of trouble, shouldn't we incentivize that?
Great. Thank you very much.
You're welcome.
Mark, I'll actually hold my questions until all of the presenters are finished.
Great, thank you, Rev. We'll move next to Keith Morrison. Mr. Morrison.
Good morning. First and foremost, I'd like to thank you, Mr. Bergstrom, Judge Leon Tucker, and Representative Kudrowski. I hope I got that right, for allowing us to speak this morning. I won't be long. Hopefully I will be effective. What Mr. Lee just spoke on is exactly my views. Judge Leon Tucker asked him a question, and the question was, what are some of the incentives for violent offenders? And I'd like to also answer that question. I think one of the incentives should be triple RI for violent offenders with ankle monitoring. I'm pretty sure that as a violent offender, that first and foremost, you have to care about the community. You have to make sure that this person is monitored as he should be. So I think that triple OR with ankle monitoring would be something that would be at least considered. I feel as though the miracle of life change is actually real. There are people who have been here for 10, 15, 20, 30 years. And a lot of times they have came to jail. We have came to jail when we were younger. And so now you're 40, 50, 60 years old, even 35, and you're not the same person that you once was. And it's almost like you're doing time for somebody else. I wrote down that the Department of Corrections be able to administrate triple RI due to the fact that the DOC knows us best. There's also something called short sentence parole that I read. And quickly it says, offenders sentenced to state incarceration with an aggregate minimum sentence of 2 years or less, or recidivism risk reduction incentive minimum sentence of 2 years or less, excluding ineligibility, as defined in 61 PA CS 6137.1, may be approved by the board for parole without requiring an interview. If an offender is committed to the Department of Corrections after the expiration of the minimum sentence, parole may be approved within 30 days after commitment. And what I was thinking about was good time parole. So it would be a short sentence parole, but not necessarily a short sentence parole in the sense that you have to have a short sentence. It will be good time parole. So if you're here, if you're showing and displaying the things that you're supposed to be showing, you're not getting write-ups, then you can have good time parole. Thank you. That's all I had.
Thank you, Mr. Morrison. Any questions or comments from the commission members? All right, moving on. The third at SCI Cole Township is Kenneth Carr. Mr. Carr.
Yes, thank you for allowing me to participate in this commission, and I think both gentlemen did a fine job They covered a lot of the areas that I wanted to go over, so mine will be short, relatively short. First thing I wanted to talk about is the parole form that you have that you assess the individuals on. And I do understand that the LSI is trying to be replaced with the strong, proposedly active January 1st, 2023, to include more diversity, African Americans, women, hopefully low socioeconomic areas that give you the reactions of the individuals that give you the chance to assess their risk. Should be a difference in that. My question about that, the change is, first of all, I'm glad that you're including something that has some diversity in it, but once it's instituted, is there a length of time that you're going to assess it to see if it's actually working? And if not, is there a plan B for the strong, or will you be reverting back to the LSI? That's my first thing. The other thing on the form is the interview process, the preparedness factors. It's understandable that the people who know you the best is your unit team that's around you daily and get the opportunity to see your growth, your lack of growth, your willingness and your remorse, and all those factors more than the board does, because they're there with you on a daily basis. And the amount of length of time gives them the opportunity to see more of you. They have more say-so in whether you've improved to the point of being released or paroled than I would say the actual board was, because the board don't actually, all they know is what they're reported to from your pre-parole agent that sends them the information given to them by the unit team. Understandably, the board will ask you the questions about the remorse and stuff, but being an incarcerated individual, you already know that they're looking for those objects. Now, I do understand that you would like to know that they have a stable reentry process with family or housing or whatever to give them more incentive not to commit more crimes. So the board does have to understand and know that factor. The other thing that comes to mind is for recommits. Recommits have their back time. Say a person is on parole for 5 years. He falls off. Understandably, the parole board, his home local office, doesn't know when he fell off, but we know from the crime that he's being adjudicated with that he has. So we don't know where the good time stopped and the bad time started, but his whole back time is taken. Now, the back time is access to the tail, which I don't know if the laws have changed. This form here I have here, the sentencing form from 2013. The parole board is not the judicial board. They don't have the right, only the sentencing judge has the right to extend your maximum. But the parole board extends the maximum onto your tail, which is increases the time. It also states inadvertently that the local parole board really wasn't doing their job, or that he was slipping under the cracks for the whole 5 years, or maybe it might have been 30 days that he committed the crime, but 4.5 of those years were good. We take it all and put it on the tail. I don't know if it's legal to do that, but they had case laws, Commonwealth, Banks versus Kane, McCluskey versus Pennsylvania, different case laws that state that that's an illegal process. Whether it is or not, you have to tell me. The other thing I have to say is, when a person is a reentrant, the main problem he has is a financial burden. There should be more programs suited to getting him trained for a higher skilled labor job, because most of the jobs he's going to get are the minimum wage, the lower scale paying jobs, fast food, etc., which barely is enough to house, clothe, feed an individual, especially with the economy today, with the prices going on today. So a person already has that financial burden. which causes a psychological burden as well. We understand that we have to pay court cost, fines, and restitution for our crimes. That's a given. But there's also a fee that the parole board assesses $135 per month from the day you're released for administrative fees that should be waived for a period of time until you at least get on your feet. That also creates a psychological trauma for an individual struggling at best to survive, and he's working and doing the right thing. So I wanted you to take a look at that. I'm at the point now, I'm 63 years old. I'm at the point now, I'm tired of being part of the problem and want to be a part of the solution. There are some great programs, just getting great reviews. Terrence Lewis is doing a wonderful job with this Project Hope. All the inmates are loving it. It's doing a wonderful job. Nate Riley, a juvenile lifer paroled from here, is doing wonderful things in Philadelphia after spending 30 some years or 20 some years in the system here. Is doing a wonderful job. There's even local in Harrisburg, Martha and Timothy White run a Miracle for Sure. They do a wonderful job helping re-entrants be incorporated back into the society and lower some of the burden that they have to face. And they follow up OVR, they follow up a year after you're in a job with materials and everything. That's what we need more of. I'm currently being paroled very shortly, and I will be seeking my master's at Millerville University shortly after being paroled. I want to take this negative and turn it into a positive. I'd love to be incorporated in one of these type of programs like Project Hope, going into the high schools, we got to start younger, going into the elementary schools, talking to these kids about the pitfalls of being incarcerated and what it can do to your future. Going into the jails, the counties, the prisons, and talking to inmates, and it don't only help others, it also would help me being involved in something like that. Give me more self-worth, and boost my self-esteem, which a lot of people coming out of prison, self-esteem has been shattered. So those are the type of things that we need. It's not just locally, it's getting attention nationally. Like this is Arizona, was in the USA last week. These people are helping people follow through, get jobs, follow through, something like OVR does. But with OVR, you need a disability. Then we need programs that don't just include disabled people, even though they say if you spend 5 years in the prison system, you're disabled. But other than that, that's the type of programs and things that we need. I've talked to many inmates in here. Some of these views are mine. The lifers want speedier times on their clemency. They're noticing that nobody's getting commutation under 25 years. They're feeling like it's just a paperwork. It's a dejecting situation for them to put some paperwork in and wait 2-3 years to get a rejection. It's really demoralizing to them. So they asked me to present that to you as well. So those are the type of things that I'd like you to take a look at about instituting some other programs and helping other individuals that'll still be here, that'll be coming into society very shortly. And I do thank you for allowing me to speak.
Thank you, Mr. Carr. I will address just one issue raised because it is central to these recommendations, and that is the whole issue of the LSIR versus the strong R. You would ask about the timeline for it. That it's somewhat outside of the commission's control because the department is working on building that, and it takes a while to build an instrument like that, specialized or focused on the DOC population and to validate it. And so it may be a while until it's done. And that is really why the commission revisited this issue. We waited, for 2 years in hopes that it would be available and validated, and it would be an improvement over the LSIR. But the starting point is the LSIR is a validated instrument for the DOC. It's just we have some concerns about differential impacts, especially for very targeted populations. And that was that was a concern that was shared with the DOC and the board. But keep in mind that the LSIR is being used today by the board. It's one of the risk instruments that's being used. And so to some degree, the guidelines are a visible, a transparency instrument. We're trying to put in place guidelines that can be considered from the outside. So the commission has thought that it's appropriate to move forward using the LSIR because it's validated. But one of the benefits, I guess, of putting guidelines in place is that we can start to collect information and assess the impact. These are voluntary guidelines. They're not mandatory guidelines. The board considers them, but the board also considers its own internal instrument. So we're trying to, collect information, trying to make this better. One of the things that we did with the preparedness factors is try to sort of document some of the decisions happening during that interview process so that those are more visible as well, that those can be tested. And so we hope this is an improvement or at least provide some insights as things go forward. But I think it's just really important to state that it's not whether we do it or not, that the LSIR is being used right now. It's a matter of trying to transition to the use of the strong R. And I think the commission wants to do that as soon as possible, but that can only happen once it's in place at DOC and it's been validated. So it may be a year or two before that happens. And then the commission will have to revisit these guidelines to build in the strong R to make sure it works appropriately in a way, maybe the same as the LSIR, maybe it'll be different, but that's part of the process. So I just wanted to give you that sort of sense of the timeline and the difficulties in trying to pick a validated instrument.
Understandable.
Great, thank you. Judge or Representative Krajewski?
Yes, Mark, I had a couple of questions. Thank you. And thank you to all gentlemen for your presentation. I really appreciate your time today and giving us your perspective and expertise on these issues. I had two questions. I'll start with the first one, which is Mr. Lee. I believe I know you had mentioned talking about wanting to expand parole eligibility to inmates who are also convicted of violent offenses. And I just wanted to ask you, in your opinion, do you believe, with that inclusion of people with violent offenses, do you believe there should be any boundary on which violent offenses are parole eligible or should be, or do you believe anyone who is held on a violent offense should have an opportunity for parole eligibility?
I think anyone with a violent offense should have an opportunity to benefit from incentive-based programming. I think that what we should focus on more than anything else is we understand that we created a harm, but if the treatment has taken place and a person has demonstrated transformation, has demonstrated change, has demonstrated that I am no longer a harmful person to the community, should we still incarcerate this person? And as of right now, we have nothing in place to determine whether a person has made these transformations or not, and to allow them to leave. Besides what my co-man, my other speaker today was talking about. Here it is, you got somebody say, for instance, that filed, even with a life sentence like I have, who filed for commutation. I've been in prison for 34 years, as I spoke up earlier. Waited 2 years to get my application heard. Been placed, had to be backed up because the laws changed. Act 59 came along and backed me up for 6 months. Being placed under advisement and still waiting for a decision. These things are very, very, draining to a person. We have to think about the psychological effect and impact that it's having on people. So I think that anybody who demonstrates transformation and shows that they have changed for the better should be allowed, some opportunities to go home early.
Excellent, thank you. And then my second question is, I know in all three of you in different parts of your testimony had referenced, what are some of the challenges for people's ability to come home and to be eligible for parole. But I was just wondering if you could speak to what you, from your experience, being inside, what do you see being some of the biggest challenges for someone who may be parole eligible? And like, what are the challenges that may discount them from that eligibility? Whether it's, you had mentioned the having the majority vote on the board versus like a full majority, or other kind of incentive things. So I'm just curious if you could share more for the commission. What do you think are some of the challenges for someone who is seeking to have their parole approved?
Well, if you're talking about from a commutation standpoint, we talking about getting things pushed back for especially a person serving a life sentence, move back from unanimous vote to majority vote. That is one of the major obstacles and impediments that's holding us up. The other thing is this: when we're looking at someone that's seeking commutation, what are the guidelines? We don't know what they are. We don't know what you're looking for. No one has ever explained these things to us. We're going into this situation blind. And you have to try to figure it out on your own. It's a mountain you want us to climb, but you're not giving us the directions. You're not telling us how to do it. So we have to figure it out on our own. And then if we can't figure it out, you get punished for that. And then in certain instances, if you do figure it out, it's almost like you're considered to be gaming the system. It's like you did too well.
Yeah,
So it's a lot of obstacles that we need to really look at. Thank you.
I appreciate it. And just a quick follow-up on that. You speaking about how you feel like you're not very informed about the process. What do you think would be a good support system to provide that kind of information and guidance for people who are seeking commutation?
We need the process to be transparent first and foremost. Let us know. Say, for instance, if you're denying a person the opportunity to go home, what is the reason you're denying them? What do I need to work on to better myself? What do I need to do so this way, the next time I come before you, I can make the adjustments that I need to make? No one is told this. It's like you go through a process, you get denied, but you don't know why. That is heartbreaking.
Thank you. I appreciate that. I appreciate your passion about this issue. Those are all the questions I had, Mark. Thank you.
Thank you, Rep.
You're welcome.
Judge Tucker, any final comments for SCI Cole Township?
Not at this time, no. Thank
Okay,
you.
great. Thank you. Thank you, gentlemen from Cole Township. Really appreciate it. If you could mute, and we're going to turn now to SCI Benner Township. And for SCI Benner, I have two individuals listed, David Bowens and Mark White, and we'll start with Mr. Bowens.
Good morning, committee. Good morning, fellow inmates. I appreciate you guys for allowing this opportunity for us to voice our opinions and our suggestions. With that being said, I'm going to jump right into it. The parole guidelines that we have in front of us. I know you stated the LSIR that we have was being transitioned away from. However, if this LSIR is validated, and is it possible yearly reviews can change those different numbers that we get that are low, medium, and high? If we get yearly reviews, we can go, a person that may come in with an initial LSIR, at let's say 34, a year from now with them taking programs, that may be able to come down to that 33, that medium status now. Now there's no longer that second factor of that high level that we have. Because now I see that we use the two factors to determine our parole is LSIR and the preparedness level scores. Now with that matrix, the matrix we have two different matrices here. We have a violent offender matrix and a non-violent offender matrix. which give us different levels. Now, when we speak of these different levels here, why don't we have since we have two separate matrices, why don't we have a violent and a non-violent preparedness level scores? Those levels that we have, it's easy for us to automatically just jump into one level and say, okay, yeah, this person has a 10, he's high, he's done. But what about that person that's trying that's non-violent, that may get a 9, but they're stuck at medium and now they can't go home? That's all I really have for that. The parole, that matrix is, man. The recommitment, the OGS, excuse me. My notes are all screwed up here. Wow.
Just tell them your thoughts.
Yeah, I'm a recommitted parole violator, and like the gentleman said from Cole Township, the fact of the state parole board taking our liberty time has been a major thing for me. I was home for 2 years, 6 months, and I was working. No negative reports on my parole. I get recommitted for a new crime, which I served 4 years in New Jersey for. And I come here and my 2 years, 6 months meant nothing. So basically I got, as the gentleman said from Cole Township, I got a new maximum sentence from a parole board that didn't originally sentence me, which isn't right. It isn't right. I was told to serve 1.5 to 5 years on a sentence. I'm well over that now. And by the time I go home, I'll have served almost 8 years on a 5-year sentence. That's really all I have.
Thank you, Mr. Bones. I will address one or two of the issues you raised just for clarity. On the first one, the issue of the LSIR, you are correct that there are both static and dynamic factors that are considered in the LSIR. So if someone is having a LSIR completed every year or one completed prior to a second review, it is possible that the score would change because there are dynamic factors, so things that could change. That is an important consideration where the guidelines could in fact be different because the LSI score would move you to a different risk level. So I think that's an important consideration that you raised. Regarding the difference between violent and nonviolent, these scales were made using the analysis of decisions that were already made and outcomes. So we were looking at how those factors played out in terms of when they were present or not present, and then what was the result in terms of someone reoffending or not reoffending when they were paroled. And so what we found was there was some difference between violent offenders and non-violent offenders. And if you look at the comparison of those two, it's only one of those boxes where it switches from recommending parole to not recommending parole. So everything else is similar, but at that place there was a difference. And so that's why we separated out the two. But these guidelines are just advisory guidelines. So they're giving a recommendation to the parole board whether to parole or not. But the parole board is going to also be using their internal instrument, and they are also going to exercise their discretion. And so there are reasons, what are called in the statute deviations from the guidelines, where the board, if recommended to parole, could instead not parole, and if recommended not to parole, instead could parole because the board retains that discretion. So it's very individualized in terms of the parole board listening to and making a decision based on the information they have. The final thing regarding recommitment, I think the commission's very interested in hearing comments for the future rebuilding of recommitment ranges. Right now, what the commission is trying to do is put in place effectively for external view, for transparency, effectively what the board is doing internally so that we can collect information and test that information. But I think, and we've had discussions with the board and with others, there may be an opportunity to really rebuild recommitment ranges, but we don't have the information right now to do that. So the commission has moved in the direction of trying to at least identify and maybe modify a bit the practice that is in place, and then try to determine using that information what the next best step would be. So we hope to keep engaged with you and other people as the commission really starts to look at that and carefully consider that, and in our work with the board itself. So I think those are important factors. The final thing I'll mention about recommitment is, keep in mind there's a big difference between technical violations and new convictions. And for the technical violations, the statute really pretty much defines what those procedures are. We've modified it a bit, but basically we're bound by statute on that. But on the recommitments for convictions, I think there's a lot more latitude there. And so I'd appreciate any kind of suggestions you think of. Feel free to write to the commission at any time because that will be under consideration for a while. So thank you. Let me turn it to the two members, Judge Tucker, Representative Krajewski, if they have any questions for Mr. Bowens.
Thank you. I have no questions at this time.
Okay, thank you.
I don't at the moment either. Thank you.
Okay, great, thanks. So the next testifier from SCI Benner Township is Mark White, Mr. White. And I believe Mr. White submitted written testimony, so members may have that as well.
Good morning. My name is, like you said, Mark White. I'm a peer educator and mentor and victim advocate here at SCI Benner Township. I'm also a representative of every incarcerated individual seeking parole from the Pennsylvania Parole Board. I would like to thank you for this opportunity to speak on this platform and for allowing me to have an opinion about important matters that, such as the parole board guidelines and public safety. I prepared a statement that I would like to present. After review of the modifications made to the proposed state parole guidelines to be considered by the Pennsylvania Parole Board when determining whether or not to grant parole to an individual upon completion of their minimum sentence, it is clear that the proposed modifications on their own fall short in terms of allowing the members of the parole board to know the actual motivations or the lack thereof of the individual being interviewed. The number one objective of the Pennsylvania Parole Board and any other paroling entity when exercising its power to parole all persons sentenced by any court in this Commonwealth is to give primary consideration to the protection of the public and to victim safety. Yet the board is relying on the professional judgment of the board members in a single-page internal guidance document to assess each individual's risk to the public, which is slightly better than chance at predicting the actual risk each individual poses. It is my opinion that practice is not fair to the individual seeking parole, and it does nothing to ensure that the public will be safe. My question and concern today is this: how could it be determined whether or not that individual has indeed utilized all of the tools of rehabilitation and correction that are available to them while incarcerated, that are designed to equip them with the necessary life skills to be able to conduct themselves in a pro-social manner and to use the resources available to them to ensure a successful reentry into society when a typical parole board interview lasts an average of 10 to 15 minutes and relies on a single-page document with standardized criteria to assess risk to the public safety. The two-pronged approach of the proposed assessment tool of risk and preparedness needs to be amended with an in-depth on-site staff assessment document of the day-to-day development and achievement of the individual during incarceration in order to raise that percentage of public safety when parole is granted to higher than slightly than better than chance. Doing so will provide the parole board with a more thorough and comprehensive assessment of the individual's preparedness for release and risk to the public through firsthand knowledge of their progress, as well as give attention to areas that need improvement before parole is granted, all of which leads to an assessment far more superior to the current documentation being used to gauge public safety and preparedness now. In prison, we are constantly in close proximity to corrections counselors, unit management, treatment specialists, as well as psychology personnel on a daily basis. There's no one more qualified to assess each individual's education and vocational achievements, taking up responsibility for their offenses, their commitment to the rehabilitative process, and their motivation for success if released, all of which are the most reliable indicators of our ability to re-enter society and function as productive law-abiding citizens. I'm asking this commission to embrace and to adopt the staff assessment document to be implemented with any guideline modifications in this proposal in order to lower the recidivism rate amongst parolees and give rise to more successful reentries into the communities across the Commonwealth of Pennsylvania while protecting the public. Thank you.
Thank you, Mr. White. And just a clarification, you were correct. The guidelines that we have are in effect a single page guideline form, and that's intended to summarize information and the metrics, the weights given to different factors for consideration for an advisory recommendation to the board. But be assured that the board has all of the information they've always had. So if you've been through an interview, you know that they have all of the background information, all of the assessments done while the individual has been in the DOC, and all of the detailed information on programming and other things like that, including the recommendation from the department, and not just one recommendation, but recommendations from the unit and from programs and so forth. So the board has a lot of information that they're using. The idea of guidelines is to try to identify some key factors that there's some uniformity in weighing some of those factors to come up with a recommendation, but not a decision. The board makes the decision, but we're trying to make sure there's equal consideration of factors across board members, and that information will be available to the public, not with names on it, but that there can be analysis publicly about what works and what doesn't, so that the commission can change the guidelines if it's appropriate. So I don't want to confuse that the guidelines replace anything. They're sort of a method of summarizing information so that there's more transparency, more people can see what's happening, more people can test whether it's working or not. So the board does a lot of good work in trying to think about all of the factors you talked about and take them into account.
Right.
And they'll continue to do that, and they'll continue to have the decision. So the guidelines are just sort of a public facing side of that process. So I hope that makes sense.
Okay, thank you.
Thank you. Representative Krajewski or Judge Tucker?
I have nothing at this time. Thank you.
Thank you.
Thank you, Mark. I have one quick question, and thank you both for your testimony. In both of your comments, you had mentioned about the issues around recidivism and folks being recommitted, and I wanted to ask if you could just share what, in your experience, in your opinion, are some of the most common factors that cause people to recidivate.
You want to go first? In my opinion, well, in my experience, the preparedness level leaving institutions across Pennsylvania set people up for recidivism, because I don't want to speak out of turn here, and I'm not the judge of anybody else's job or anything like that, but many of the groups and programs that are available to us in the DOC All you have to do is show up and it's a completion. Nobody is there to make sure that you are, like I said, committing yourself to the rehabilitative process. Let's take GED, for example. All you have to do is have a certain amount of hours and you're considered good enough. Why isn't that mandatory going out of here, which is going to give people an opportunity to you know, at a better opportunity at finding employment once released, or you know, just some type of vocational programs. Why aren't they mandatory? Why are they voluntary? Those things will ensure that, you know, the recidivism rate goes down, because if somebody is prepared to, you know, with the education and the skill to provide for themselves and their families once released, I mean, that lowers the recidivism rate, in my opinion.
Have anything else to add? No, he got it all. Okay. Thank you. And so it sounds like what you're saying is that there are programs available, but there may not be enough accountability or support for people who participate in those programs to make sure that they are getting what they need to be prepared for reentry when they come out. Is that correct?
Right.
Okay, got it. Thank you. All right, that makes sense to me. That's all I had.
Great, thank you, Representative. And thank you, gentlemen from SCI Benner Township. Really appreciate your comments. I know you raised and others raised the issue of clemency, which is really a matter for the Pardons Board, not for the Parole Board or parole guidelines. But what the commission can do is take your comments and summarize those and provide those to the Board of Pardons as concerns or issues that were raised during this public hearing. So thank you for your comments on that. With that, if you could mute your site, or the DOC could mute the site. We're going to now move to SCI Fayette. There's 3 individuals, I believe, that are scheduled to testify: William Allen, James King, and Algin Earl Youngblood. So with that, if SCI Fayette is unmuted, we'll start with Mr.
Yes.
William Allen. Mr. Allen.
Thank you. I would like to begin by thanking the commission and all those in attendance for taking the time to recognize and address such a difficult and complex issue. I'm both honored and heartbroken to be here with an opportunity to speak on behalf of those who will be affected most by these proposed guidelines. I'm honored because I get to lend my voice to a conversation that up until recently would have taken place without our input. However, I'm heartbroken because I had hoped to have earned another opportunity to redeem myself outside of these prison walls by now. I am by no means attempting to take on the role of the victim here. I committed the crimes I pled guilty to on both occasions, and I'm responsible for the pain and the irreparable damage that I've caused to so many in the process. I sincerely wish that I can undo all of it, but unfortunately, that's not possible. In trying to balance the safety of the public, the rights of the victims and their families, as well as try to gauge what would be in the best interest of offenders and our loved ones, it can seem at times that there are no real solutions to the problem. The LSIR and the proposed guidelines, although imperfect, are merely advisory, and the board is permitted to deviate them, quote, based on the professional judgments of the decision makers. This means that everything comes down to the discretion of the board ultimately. Please don't get me wrong. I can appreciate the need for the board's human factor in the decision-making process, especially when admittedly concerns have been raised about the LSIR and its validity for the African-American and female populations. However, I also believe that without any oversight, it could be a double-edged sword, allowing for decisions to be made based off of biases as opposed to actual preparedness. For example, I was blessed to be released on parole in 2005 after serving almost 11 years of my initial 10 to 20 year sentence for third-degree murder. I was rearrested in 2009 for 2 counts of possession with intent to deliver and 2 firearm violations. I pled guilty and accepted a sentence of 5 to 10 years. Upon my recommitment, the 4 years and 2 months I had spent out on parole was forfeited, extending my original maximum sentence from 5 years left to 9 years. I was also given a 2-year hit, which was the maximum sanction allowed for my violations at that time. I served those 2 years without incident, and I complied with my prescribed programming. However, I did not get the institution support. And after being interviewed, my decision came back stating that I should serve out the remaining 7 years of my original sentence before starting my new one. I applied for parole after a year, and 6 months later, I was re-interviewed, at which time the decision came back saying that I would be reviewed again in 1 year. After that year, I was interviewed and told to max out yet again. I applied for parole a second time after a year, and 6 months later, I had another interview. This decision came back with an 18-month hit. At the completion of that sanction, I was interviewed again, and after 8 years, I was finally granted parole to my new sentence. I recently finished serving the minimum of my new sentence and was interviewed for parole this past October, and I am now currently serving another hit and should be reviewed again this July, God willing. Throughout this whole process, I've had to respect the fact that people will look at my situation and think and feel differently about me. With all of those interviews, there is only one board member that I've seen twice, and on both occasions, he had recommended that I max out. Despite his recommendation, during the second hearing, he said that he acknowledged all that I had done, both outside of prison and since I returned. He also said that he felt I deserved another chance, but he could not be the one to give it to me. And out of fairness to me, if he should ever see me on his docket again, he would recuse himself from my hearings. Although I may not have liked his decision, I could only respect his point of view and his candor. He said he was looking at the fact that I was released on such a violent crime and chose to pick up another gun. Regardless of if I had used it or not, I still had it. He also said I was asking for yet another chance that my victim had not been afforded. And because of those two things, nothing I did before or after that could ever supersede those facts in his eyes. Some of the other board members who either gave me lesser sanctions or those who granted me parole said that they recognize that I am truly remorseful and I understand the gravity of what I've done. They looked at my parole supervision history and saw that while out on parole, I kept a minimum of 1 job up until the recession hit, that I had completed a year of community college and that I was registered to resume classes again in the fall in pursuit of my associate's degree in electrical technology. They said that they recognized that since returning to prison, I had not only completed my prescribed programming, but I was hired and trained to co-facilitate all the groups that the DOC had to offer. Also, how I had been trained and worked as a licensed certified peer support specialist in the institution, and I hadn't had so much as one misconduct since I've been back. Between being granted parole in 2017 and my most recent parole denial, the only things that have changed is that I came to SCI Fayette on a promotional transfer, maintained my CPS license, and have attempted to assist my peers in every way I could, from mentoring and tutoring to working in hospice. And I also got the opportunity to study and acquire both my cosmetology and my cosmetology teacher's licenses since then. Outside of that, I've done nothing different. I can understand that there are no absolutes. Each offender in each case, despite their similarities, are different in their own respects, and they have to be dealt with individually. But also, every person who can make a decision on how the two aforementioned factors will be handled all have their own individual thoughts, feelings, beliefs about what they're looking for and how they would deal with any given situation. So I respectfully ask, if we can't ensure any uniformity in the decision-making process, then how can there ever really be any consistency? For the record, I did not do all that I've done in an attempt to impress the parole board. I did them because I was able to recognize the areas I fell short when I first came to prison at age 15 and vowed to do better with my time and opportunities to prepare this time. I did them because I took a life I can never replace, And I hope in giving back, I can help save some and possibly be forgiven. I did them because I've lost both of my parents during this bid and promised them on their deathbeds that I'd strive to live up to my potential and I wouldn't go backwards again, no matter what. I did them because a lot of people have believed and invested in me, and I feel they deserve to see a return in their investment. And I did them because I'm determined to work so that my story can end as one of redemption, not merely a cautionary tale. Thank you again for your time and attention.
Thank you, Mr. Allen. Judge or Rep? All right.
No, I have no questions at this time. Thank you.
Neither do
Thank
I.
you. Next is James King. Mr. King?
Good morning again, everyone. I'd like to thank everyone who's in attendance today to hear some feedback on these proposed guidelines. Regarding parole, I think it's good that the new risk assessment instrument, Static Risk Offender Needs Guide, will provide more reliability and validity to facilitate reentry and reduce recidivism. Also, giving greater consideration to progress in rehabilitation, treatment, and education will be better served in the decision to grant parole or not grant parole. What an individual is doing to help reform their past behaviors, I believe, is more important than their past behaviors themselves. I believe it would also be beneficial if inmates were more aware of specific areas the parole board considers when making a decision to grant or refuse parole. For example, the LSIR, the 10 criminogenic domains that help predict success or failure on parole, will be a good list of goals for inmates to be aware of and work forward to. It's also good the guidelines themselves encourage more programs and prioritize the need for either further incarceration or rehabilitation outside of prison. I'm saying there's a lot of good things with the modifications you guys are looking at. It's fair but tough, but there's still a few problems. I also think an inmate should receive a copy of their completed parole guidelines form, the 309.5, with their green sheet, particularly if they are denied parole and the guidelines are deviated from, because it would be nice to see why the guidelines are being deviated from and what that person needs to work on. So next time they see parole, they have a better chance at it. It would be beneficial to see what areas they are lacking and why the guidelines are deviated from. Under recommitment, linking the offense gravity score of a new conviction with the recommended recommitment range seems fair, but the 2-point increase for subsequent offenses is just too harsh and only adds the lengthy recommitments, which do nothing to reduce recidivism. And that's the goal, to reduce recidivism. The longer a person is institutionalized, the harder it is to be successful on parole. So keeping people in prison for longer and longer with harsh guidelines isn't going to do them any good. I believe a large percentage of recommitments would be better served in a rehabilitative environment outside of prison. It is clear that our testimonies were heard and considered, and we thank you for that. We were here in 2020. The revised guidelines appear to be more open-minded, but some of them seem unnecessarily harsh. The attempt to find more reliability and validity in the decision-making process inspires hope for what I would call consistency and fairness. If an inmate does all that is asked or required of them, they deserve parole. And the people closest to them, for example, staff members, would have better insight into their potential for success or failure on parole, not a software program, whether the LSIR or the Strong R. Believe and rely more on the staff that you pay to rehabilitate us. Thank you.
Thank you very much. Questions or comments from the commission members?
Mark, I'll hold off until the last
Okay.
time.
Thank you, Judge.
I have none.
Okay, thank you. The third testifier then is Algin Earl Youngblood. Mr. Youngblood.
Thank you. Good morning. First, I would like to thank you for giving me the opportunity to express my testimony. My name is Elgin Youngblood. I was once a convicted parole violator, also a second-time offender. So I find these topics important. However, just because I am an offender doesn't mean that I don't understand or appreciate the enormity of the commission's task and stance when it comes to public safety. One point brought up consistently by the inmates that I viewed these topics with was being convicted of a violent crime in the past, and we have paid the debt and have maxed our time out, and over the years of not committing a crime, and then we committed a crime that was non-violent. Well, when we come see the board again of a new crime that we pay, that we in jail for now, that we're deemed as being a violent offender, compared to our previous crime that was passed 20 years ago that we have maxed out was violent. My thing is, why are we still deemed as a violent offender? Okay. We understand that the point of these guidelines is to serve as a guide or deter from not reoffending or has a tendency to reoffend. I feel like that gives some examiners to be biased as their discretion, which leads us to another area of concern. The 10 criminogenic domains, what is part of the parole risk category. I would like to know more about these when preparing to have an interview with parole, to see the work on these, to know what I need to do to have the more successful in being paroled. One great thing I like and understand also that the inmates I talked to on this topic concerning parole violators is that the Act 122. I feel like that's a great program to give the parole violators another chance. Another concern of a convicted parole violator is the violator has been compliant. When we've been compliant with majority of our stipulations on the time of liberty, why can't there be a partial forfeiture of street time instead of losing it all? I can conclude my views and expressions by saying I understand that the safety of the public is paramount in the decision-making process. I would like the board to recognize that although the negative actions of our past can serve as indicators of one's chances of recidivism in the future, but also all the positive actions of our past and present can also serve as indicators of our changes to succeed in the future. Thank you for your time and consideration.
Thank you, Mr. Youngblood. Judge or Rep?
I have nothing at this time, but thank you very much for your comments.
Representative?
Thank you. Yeah, thank you, Mark. And thank you all for your comments and your testimony. I think I just have like a clarifying question, just so I understand it correctly. I believe it was referenced that in regards to the 10 domains, that inmates are not, that you, or at least were not given that information prior to your hearing. Is that correct?
Yes.
Okay. And then I think Mr. King, you had referenced that afterwards, after a decision is made, that the inmate isn't given, or you're at least requesting that the inmate be given some kind of sheet or document outlining the decision and what the deviations were from the guidelines based on that decision. Is that correct?
Correct. Basically, what I'm saying is when we receive our green sheet, specifically if we're receiving a hit, and specifically if the guidelines are being deviated from, I think it would be beneficial for us to receive a copy of the parole guideline worksheet and an explanation of why the guidelines were deviated from.
Okay, got it. So you're basically saying, if it's something that is a deviation, that you would like an explanation of that and why that deviation was made.
Right. In my personal opinion, the green sheets are just a basic, here, you got a hit. It's not really explaining what the interviewer's thinking or how the parole board is viewing you and what they believe you're still doing wrong or what they believe you need to work on.
Okay, got it, understood. So it's basically, it's trying to figure out how can more information be given on that sheet for the inmate to know for their own rehabilitation. That seems pretty reasonable to me. So thank you. That's all. Sure.
If I may, regarding the 10 criminogenic domains, the list of the 10 domains, and this is my experience from speaking with inmates on my block, they don't realize that any of this stuff is taken into consideration regarding parole. I mean, criminal history, obviously, education and employment, drug and alcohol problems. But when you start getting deeper into the 10 criminogenic domains, companions, emotion, personal lives, they don't realize that that's a part of it. It would probably benefit them to know that stuff. That's all.
Yeah, no, I think that makes sense, since those are things that are a little more intangible and aren't necessarily things that you can like point to in the same way. So I think that's a really fair observation. So
thank you.
Thank you. That concludes my questions, Mark. Thank you.
Thank you, Representative. And thank you, gentlemen from SCI Fayette. Really appreciate it. If you could mute on that end. And now we'll turn to our final location, SCI Muncie. There are 3 individuals scheduled to testify: Heather Lavelle, Amelia Lockwood, and Christina Rubin. So we'll start with Heather Lavelle. Ms. Lavelle.
Thank you. My name is Heather Lavelle. I've been serving a life sentence at SCI Muncie since 2006. Thank you for the opportunity to speak today. While the topics of good time credits and parole eligibility for lifers are incredibly important, these topics were discussed today and in prior public hearings. Today, I want to focus on the risk assessment model and the violent offender matrix. I can't stress enough the importance of having a risk assessment tool that is predictive for women based on their needs, that takes into consideration their pathways to incarceration. Trauma seems to be the common thread that links incarcerated women together. Mental illness, addiction, and abuse need to be addressed from the beginning of a sentence, while the woman is building education and life skills that will keep her out of poverty and marginalization upon her return to society. Transparency is key. Women need to know what's expected of them at every step of the parole process, prior to release and as they transition to the community. Women start over when they leave prison. They need to build their lives from the ground up, leaving behind the unhealthy relationships and situations that brought them to prison in the first place. Without support, this can be nearly impossible. Often, women are immediately thrust back into their roles as full-time mothers and caregivers, while they try to incorporate the therapeutic tools they learned while incarcerated that help them thrive in the structured environment. Shouldering the family's burdens can be overwhelming and can lead women back into self-destructive patterns of behavior that often end in reincarceration. Failure for women starts at the point of feeling overwhelmed and being unable to access resources needed to get them through these difficult times. It's often challenging life circumstances that lead women to commit acts of violence. Anyone can commit an act of violence. It's part of the human potential. In my personal experience, acting out in violence and coming to prison forced me to see myself and my life clearly for the first time. I needed help, and it was in prison that I began to rebuild my life. I would argue that I'm less likely now to commit an act of violence than I ever have been. But the guidelines show that I will always be judged more harshly for having violence in my history. I recommend using one matrix, offering more people the opportunity to parole out of prison. The preparedness score includes the key factors for both violent and non-violent offenders of acceptance of responsibility and insight into criminal behavior. And Mr. Bergstrom, you mentioned that the data, perhaps that data can be reviewed for differences between one-time violent offenders and habitual violent offenders, and some change be made in that. I encourage the commission to consider more opportunities for credits in the guidelines, not just sentencing enhancements and punishments. All sentences should have the goal of integrating the incarcerated person back into society with the skills and tools they will need to be successful. No sentence should leave a person with no hope for the future. I suggest the institution's recommendation be given 2 points instead of 1. With 2 static factors in the pre-interview preparedness score, a violent offender will never receive parole with a low risk score, which also includes many static factors, possibly disproportionately impacting women with a trauma background. The basic assumption appears to be that people cannot change. I can assure you that based on my own experience and that of many other women, people can and do change. There comes a point where long-term incarceration no longer benefits the incarcerated person. It only makes it more difficult for them to ever fit back into a constantly evolving society. It doesn't benefit the public either, costing millions in healthcare and prescription medications for people who have aged out of crime. We can redeem our pasts, and the sentencing guidelines can reflect this by, number 1, offering more opportunities for credits, number 2, allowing success in the community to lower a person's offense gravity score, and 3, by offering more alternatives to incarceration, such as enrollment in programs and community services. In closing, I'd like to share a little about the impact COVID had on us here at Muncie, clearly showing the need to reduce the prison population. 2 years of isolation and lack of stimulation resulted in an increase in mental health symptoms and self-defeating behaviors. There wasn't enough staff to run the prison and do all the jobs the residents generally do. The psychologists were working in the kitchen to make sure we got fed. The need for mental health services was never greater or more obvious than it was during COVID. Besides using parole, furlough, and reprieve options, technology can be used to make sure our population's needs are met during an emergency. Mental health services can be made available through the tablets or the video visitation system. I hope we're moving closer to the day when all of Muncie's residents are parole eligible, and I believe the DOC can do more to prepare us all for our eventual release by rescinding the policy that limits lifers from programming and by adding more therapeutic opportunities for all residents. Thank you for your time and consideration of my testimony.
Thank you, Ms. Lavelle. Comments or questions?
I have none, but thank you very much for your detailed explanation of your thoughts. I just really appreciate that. Thank you.
I echo that. Thank you for your testimony. I don't have any at this time, but we'll wait for all the testifiers to go if I have questions.
Sounds great. Thank you. Next is Amelia Lockwood. Ms. Lockwood.
Good morning. My name is Amelia Lockwood. I'm honored to be here today and to be given the opportunity to participate in this matter. I am a nonviolent convicted parole violator. My criminal record in its entirety is composed of several counts of retail theft and receiving stolen property. I have been serving a 4 to 10 year sentence over the course of the last 13 years and have spent approximately 9 years incarcerated at SCI Muncie. Addiction is the impetus of my incarceration, yet I am solely responsible for the time I have spent in prison. I would like to begin by saying I exponentially agree with the proposed state parole recommitment ranges for technical and convicted parole violations. I believe the ranges themselves are adequate and fair, along with the procedures used to determine the appropriate recommitment range. My primary concern is the frequent use of non-variable factors by the parole board to ultimately deny an offender parole. Reasons including but not limited to poor supervision history, having a state detainer, and risk to the community are often utilized by the board to continue the incarceration of a parole violator after they have served the initial back time imposed, sufficed all requirements in the board action, and had the institution's recommendation for parole. More often than not, these same static factors were already used as reasons to impose the initial back time. The issue is, these are all things we cannot change or improve upon. Additional incarceration cannot change an offender's supervision history, nor will it change the fact that they may have a state detainer. I understand that being a risk to the community is a more common complex topic because the parole board has an obligation to protect the community. My understanding is that a risk score is a calculation made prior to an offender being interviewed. Yet I am unsure if the score ever changes. Using myself as an example, at the time I was interviewed, I had been incarcerated for 19 months. The board determined I'm a risk to the community and should be reviewed again in 6 months. This is the 4th consecutive board action determining I am a risk to the community. Will that score be different at 25 months of incarceration compared to 19 months? I speak not just for myself, but for many offenders when I say we feel defeated when we cannot improve upon the things that hinder our freedom. Increased specificity during interviews and/or in the board action would assist the offender with the comprehension of being denied parole and what they can work on moving forward. The utilization of CCC placement mandated by the board presents as an adequate solution. Instead of imposing additional incarceration time due to the static factors I spoke about, using a placement in a center for a specified amount of time as a more controlled way for an offender to reintegrate into the community. The structured environment poses as a method to closely monitor the offender while also allowing them to obtain employment and be a contributing member of society. Currently, it is extremely rare, if at all, that the board uses this positive alternative for those eligible for re-parole. This not only benefits the offender, it benefits the financial burdens associated with the incarceration. It seems unnecessary for the parole board to repeatedly litigate the re-parole of an offender whose new conviction was resolved on a county level. When an offender receives a county sentence for a new crime, they must serve the county sentence prior to serving the back time imposed by the board. This means the offender has already been paroled and/or released by the county. Therefore, the offender's ability to safely re-enter society has been decided on the level determined to be fit by the judicially imposed sentence. I categorically understand that committing a crime while on parole is a violation of parole and subsequently requires a consequence. There are guidelines and factors used to determine how much back time a convicted parole violator should serve. Implementing a process such as presumptive parole not only balances the fairness, but would alleviate burdens on the parole process. The last topic I would like to speak about relates to an offender's time spent at liberty on parole. I've received a tremendous amount of feedback from my peers on this topic, which I too have similar concerns. Many offenders, including myself, have spent significant periods of time on parole in good standing without violations. The board has discretion whether to award the time or not, and there is no consistency with who gets credit and who does not. We would like to see the discretionary aspect removed and a more formulary method implemented where time spent on parole without violations is awarded to perhaps nonviolent offenders or where the new conviction is nonviolent and/or a misdemeanor offense. Thank you for inviting me here today and listening to my concerns. I'm grateful to be given the opportunity to contribute to something of such great importance.
Thank you, Ms. Lockwood. Any questions or comments? Okay, then we'll move to the final testifier from SCI Muncie, Christina Rubin. Ms. Rubin.
Thank you for allowing us to speak today. My name is Christina Rubin. I've been incarcerated for 13 and a half years for voluntary manslaughter. I have seen the parole board 3 times and received 3 hits. From my personal experience, it seems like parole already has their minds made up. You sit in front of 2 complete strangers that judge you based on a piece of paper, not the changed individual sitting in front of them. Every time I've seen parole, I've had the institutional recommendation, yet it seems to mean nothing. This recommendation entails maintaining a positive housing report, a positive work report, and receiving positive notes from the COs and staff. The housing report is done by the unit officers and the unit manager. When the long-termer is going up for parole, there's a good chance they've lived on the same housing unit for some years, allowing the unit officers and managers time to get to know the inmate. The same applies for work reports. Most of the jobs here at Muncie allow for employment for 3 years before moving to another job. Myself, as well as other long-termers, feel that the institutional recommendation should hold more weight than it does. How is it that I keep doing what's required of me, including having this recommendation, yet I keep receiving hit after hit? It gives us feelings of hopelessness, instability, and anxiety. Once we receive our green sheets, which could take upwards of 6 to 8 weeks, it never explains how to make parole. In fact, on my third denial, there was additional criteria that was not listed on my first 2 green sheets. Why can't there be presumptive parole that allows inmates the chance to do what's required to make parole and become a productive citizen? My final observation about parole is when they decide to max people. When they decide to max a long-termer, I believe that's a recipe for disaster. When an inmate maxes, the DOC is legally obligated to release that person, regardless if the inmate has secured housing or a job. The state no longer is required to help. Maxing someone is no different than having a flat sentence. However, a flat sentence allows for an inmate to properly plan for a future. When someone knows they only have 2 years left and they don't have to worry about seeing parole and getting their hopes up, they can more positively and properly plan for a future. With a flat sentence, one can make the necessary phone calls to family or friends and have their living situations in order. Also, one can obtain employment much easier. There's only but so many times an employer is going to hold a position open when someone keeps receiving hits. However, the only downfall with a flat sentence is that once you leave, the state offers no assistance, hence why parole is so important. When on parole, there is structure. There is still help in our corner. Parole allows us to have a parole agent who can assist with jobs, community service, housing, etc. In conclusion, long-term offenders should be given a fair second chance at redeeming themselves and becoming a productive citizen. Thank you for your time and consideration on this important matter.
Thank you, Mr. Rubin. I'll turn to the judge and the representative now.
Thank you very much. No, I have nothing. It's rather touching to hear the testimony of all the individuals incarcerated. It seems to me that everyone is pretty much saying the similar comment that it's not fair. You're asked to do something, but you're not told what it is that you're to do. I will do whatever it is I can as a member of the commission to see that that's addressed. Thank you.
Thank you, Judge. Representative?
Thank you, Mark. And thank you to the testifiers for your testimony and your experience and your expertise on this. I really appreciate it. And I extend to all the testifiers today. I definitely have learned a lot and I'm digesting a lot from all of your diverse experiences. My question for the testifiers at Muncie is, you had mentioned all 3 main parts of your testimony, mentioned the way that trauma and other environmental factors play a role, particularly with regards to women around both initial offenses, but also reoffending. And I'm curious if you could just speak more to how you think we could be mindful of that as a sentencing commission and what that could look like in terms of, recommendations, guidelines, or support systems where we can be particularly mindful of the environmental factors, right, that women have to deal with when it comes to both offending and also reoffending.
Sure. Trauma impacts, I believe, somewhere around 98% of the women that are incarcerated. And in my experience working with the women at this institution, it touches all of our lives. It's part of what led us here. And in large part, it's untreated trauma that keeps us coming back. So I believe very strongly that women need trauma therapy. It's a lifetime process. Your trauma never really goes away. You can treat it, and you can learn to recognize your triggers, and you can learn to implement action plans when you are triggered and when you start noticing your symptoms manifesting. But this needs to go on while you're incarcerated. The self-awareness that one learns while they're here is a huge help in that, but also wraparound services that transition to the outside. So you're not just left to your own devices when you're facing all the temptations that you're going to find outside the fence. And not just, I shouldn't say temptations, but the stressors that will trigger us, and without the appropriate services available and ongoing long-term therapy, that can lead to us making bad decisions again, poor choices, unhealthy relationship choices, all the things that would then ultimately lead to our reincarceration. So I think it has a lot to do with services. I think the prison environment can assist for a period of time, but then women need to learn, and I'm sure the men do too. Sorry guys, I just think about women, but the women need to learn how to live in the world. So keeping them isolated from family and real life situations isn't helping them learn, you know, how to adjust and live with the tools that they have learned here while they're facing the real life stressors.
Thank you. And then just a quick follow-up to that, in regards to what you were saying around, like, you know, trauma therapy, maybe trauma-informed therapy and care. Can you speak to what, if any, kind of services around that are available for current inmates?
None.
None. Okay.
Unfortunately, there is a House of Hope program that's a voluntary program for women who have been victims of abuse. I believe it's a limited number of women that get in there. I believe that they shy away from really head-on dealing with the trauma, especially the trauma of sexual violence. And I think it's inadequate. And then also we're coming off of a stretch of 2 years where that service has not been offered at all. So it's challenging here.
Yes, thank you. I definitely can hear that and see that in terms of the testimony and experience that you brought today. So definitely thinking about how we can be of better service in regards to that kind of therapy and services as well. So thank you. Those are all the questions that I had, Mark.
Thank you, Representative. And I believe we've concluded the testimony that was scheduled. Let me just make a couple of comments. One is that, as I said before, we heard comments regarding the clemency process, which is under the purview of the Board of Pardons, not the Sentencing Commission, not the Parole Board. And so we will gather any kind of comments related to that and forward those to the Board of Pardons for their consideration. We also heard a number of suggestions related to the guidelines and recommitment ranges. So the commission will be meeting tomorrow and Thursday, and so we'll review those comments and any other comments we receive and decide the next steps if the commission feels that the guidelines as published or with minor modifications are ready to go. The next step would be for the commission to publish and submit these to the General Assembly for a 90-day review. And at the end of that review period, if not rejected, then they could go into effect. And I think the target date would be January 1st of next year. There were other issues raised outside of the guidelines themselves, but more procedural things, questions about the information, making the guideline form available along with the green sheet, additional information to inform individuals about the LSIR and the 10 domains, or about other factors that may be helpful in preparing an individual for parole or for understanding why parole was refused. And so we'll discuss any of these with the parole board. Again, it's really their decision on how they operate those things. But if there are means of incorporating them into the guidelines or the recommitment ranges, either now or in the future, we'll at least make note of that. And then there were issues raised, especially about recommitment, about street time, time at liberty, back time, and so forth. and particularly in terms of convicted violators. And so we'll also have those discussions with the board, but also consider that whether with these recommitment ranges or things we consider in the future. And as I mentioned at the start, it's sort of a fluid situation. We know that the DOC and the board are working on the strong R. We hope that will come into play because it does address some of the concerns that were raised about an effective risk assessment tool that could be used for female offenders to address things like domestic violence and trauma and other issues. So we really look forward to the day that instrument will be available, but we do to some degree have to work with what we have and recognize that it's in use right now with board decisions. So there may be some benefits in moving forward, even if it's imperfect. So we will continue to try to make sure that we make the public aware of this, but I wanted to cap that off during this call today because sometimes you might not have as much access to the information. So I wanted you to know what the commission would be doing and what decisions they have before them. But I do want to close in thanking our members for being present, thanking the individuals that attended this hearing. And I believe at one point I thought we were over 50 individuals observing or participating. So I'm really thankful for that. And I will note that tomorrow we have a second public hearing scheduled. It's a hybrid hearing. So the hearing itself will begin at 2 o'clock in the Irvis office building, room 523, beginning at 2 o'clock, but it will be simulcast. I don't know what the right term would be for Zoom webinar so that we will have a hybrid meeting. So I know we have at least, I think 4 individuals scheduled to testify via Zoom, but it's open to the public. So if anyone listening is interested in testifying, please feel free to come in person or to register for Zoom. I'm going to close by thanking I guess 11 individuals that testified. This was very meaningful as it was 2 years ago to the commission, and the commission looks forward to continuing having these types of hearings anytime there are guidelines being considered by the commission. So I want to thank you for your thoughtful testimony and really helpful recommendations and suggestions. And I also want to thank the Department of Corrections for all their help in arranging this, both in the institutions and the administrative office. So thank you all. And if there are no other comments from the judge or the rep, we'll conclude this hearing today.
I have no further comments, just to say thank you very much for all of the participants.
Thanks, Judge.
Yes, now I'll similarly thank you all for your testimony and your experience. I think it is critical for us to consider the people who are currently inside the system and our correction system to be, part of the conversation of how we make it a place that actually upholds rehabilitation and reform and having folks be able to come home after their period of accountability. So definitely appreciate all of you being willing participants and us trying to perfect that. So thank you again, and just greatly appreciate your time.
Great, thank you all. And this hearing is concluded. Thanks.